The most important thing somebody needs to bring to the initial meeting would be the child's birth certificate, whether it's in Virginia or in another state. If the biological spouse or biological parent is no longer living, the other parent, then the death certificate for that parent, and then a comprehensive list of why this step-parent adoption is in the best interest of the child, because that is what the court is going to look to when determining whether to grant this adoption. So it can vary depending on the facts and circumstances, just like so many cases, but typically if the adoption is not contested because the biological parent is either unknown or is no longer living, then there may be perhaps one additional case prep meeting here with an attorney at Smith Strong. Documents are filed with the court. There may be a hearing. There may be an interlocutory order that's entered, but that can often be waived if you have the proper legal counsel. So after the initial consultation for a step-parent adoption, the process typically is straightforward, involving a lot of paperwork that the court is going to ask for. A petition needs to be filed with the court, and depending on how that petition is worded and the facts and circumstances around that case, the court may enter what's called an interlocutory order. They may appoint a guardian ad litem to represent the best interest of the child. Depending on the facts and circumstances, they may not do any of that and go straight to entering an order of adoption. And so a hearing is possible, especially if there's a guardian ad litem involved. If it's contested by the other biological parent, there could be a more contentious hearing. If it's not contested, or if the biological parent is no longer in the picture, and it might be much more straightforward. Sometimes the adopting parents will have the option of a hearing for the ceremony of it, to have the child know that this is my new parent. Other times it can be handled, quite frankly, through the mails, as long as your attorney knows exactly what they should be filing. If all parties are in agreement and you can articulate to the judge through your petition that this is in the best interest of the child, and either both parents agree or one of the parents is deceased or not in the picture for whatever reason, then a hearing very often is not required. And the judge is willing to take the petitioning biological parent at their word that this is in the best interest of the child, so long as the attorney has prepared the documents appropriately. Grandparent adoptions are authorized under Virginia law as persons with a legitimate interest, and this isn't exclusive to grandparents. It could be the long-term partner of a biological parent. They're not legally married, but they're in a long-term committed relationship. That might be a person with a legitimate interest. And what I would counsel is that you, again, need to ensure that the best interest of the child is being represented. Very often it is, because with this adoption, now the adoptive grandparents or the person with a legitimate interest can add that child onto their health insurance, can make certain tax elections. There are any number of reasons why it's in the best interest of the child, can make school decisions, medical decisions for this child. So very often it is in the best interest. You just need to be able to show the court why it is so important for the child and is in their best interest. So the state law refers to a person with a legitimate interest, and it doesn't go much more beyond defining what that is. There are a few references to other code sections, but it's a little bit vague. And I think it's done intentionally because the General Assembly knows that they can't account for every possible situation. A grandparent, a non-married, long-term partner, whatever it may be, it could potentially be any number of situations. So they've left it intentionally vague, and it is up to the Smith Strong attorney to show the judge why this person has legitimate interest. The best advice I can give is to first make sure you're getting a good legal representative, because this is a difficult area to try to navigate by yourself. And beyond that, make sure you have documented very well why this proceeding is in the best interest of the child. And as long as you can show that to a judge and it's uncontested, if you have a contested case and you're trying to take someone's parental rights away, that's a little beyond the scope of today's conversation, but showing the judge that this is in the best interest of the child and that all parties agree the best thing you can do to prepare for that proceeding.